Okay, I think we'll get started. My name is Troy Lanigan. I'm president of the Canada Strong and Free Network, and I want to welcome you to April's Exchange Call. First and foremost, we couldn't do this without sponsorship, so a very special thank you to our sponsor, the Modern Miracle Network. Before we start, I want to plug this year's Canada Strong and Free Networking Conference. It's taking place May 5 through 7. At the Shaw Centre in Ottawa. Our opening night features a debate amongst candidates vying for leadership of the Conservative Party of Canada. We also have many great topics this year, including healthcare reform, what's happening in our cities, the future of work, the growing cost of living crisis, hotspots around the globe. And we're pleased to have as one of our keynote speakers, North Korean defector and human rights activist, Yunomi Park. If you've not heard this young woman speak, she is absolutely amazing. And as a thank you to everyone for coming on to our call today, I'll extend a discount code. I'll ask Zoe to put C2C Friend 22 into the chat. You can use that code, and also Zoe put the link to the conference in. That code will give you 15% off our early bird rate that ends next week. Okay, on to our exchange call today. The Charter at 40, success or missing in action. First of all, we will let the chat function run today with the usual reminder that we'll remove anyone that's posting any rude or objectionable comments. The chat is for commentary and for networking, and I'm sorry for those of you that don't like the chat, but it does run. It's not, we can't turn it off. The Q&A box, which is at the bottom of your screen, is for questions. Don't put questions in the chat. If you have questions for the panel, please put them into the chat box, and our moderator will be monitoring that as well as our panel. Second, if you have suggestions for future topics, our next one's going to be June because of our national conference next month. We're not doing one in May. So please connect through our website or connect with me directly at troy@canadastrongandfree.network. Again, I'll ask Zoe to put that into the chat. Finally, this Zoom call will be recorded and posted to our website and to our YouTube page about 2 hours after the call. Okay, no one came here to hear me speak this morning. With that, I'm going to welcome our good friend John Robson, best known through his columns and commentary, but I'll also mention his documentary, The Climate Discussion Nexus, and also John is involved with an event this month, The Climate and COVID Meeting the Return to Freedom Challenge, taking place April 22nd, 23rd, and at the end, John, you are welcome to plug that as well. We'll make sure that link gets into the chat for you. And with that, John, thank you again. I'll turn it over to you to introduce our panel and lead our discussion for the next hour.
Thank you very much, and thank you for doing the plug. So I won't distract people with that, except I will put it in the chat at the end. I'm about to introduce our three distinguished panelists. I just want to say first that we are going to be here for the next hour, well, 56 minutes now. I'm going to ask each of the panelists to speak for 5 minutes, and then I'm going to enforce that fairly ruthlessly, and then we will have a discussion in the question period, and we will finish on time. Years ago, when I was at the Fraser Institute, I was very impressed by a piece by Paul Hain on why the bus shouldn't wait for the person who's late. And I've put up a link to it there, but the essence of it is that we really appreciate you giving us an hour of your time, and we intend to fulfill our end of the bargain and do what we're here to do in 1 hour. So you're all hoping that at 1 o'clock you can get on to the next thing, and we'll let you do that. So our panelists, as you are presumably already aware, but I will just remind you, first of all, we are joined by Brian Peckford, PC. He was Premier of Newfoundland from 1979 to 1989 and is the last living drafter and signer of the 1982 Constitution, the Charter of Rights, of which is our preoccupation in this meeting. Then Suzanne Anton, QC, is a former Attorney General of British Columbia and a former Crown Prosecutor, and Bruce Pardy is the Executive Director of Rights Probe and a Professor of Law at Queen's University. That's the order in which they'll speak. So, Mr. Peckford, over to you.
Yeah, thank you very much. I'm very pleased to be here this morning to discuss your topic. I have to say off the top, however, that the topic may be a tiny bit wrong in the sense that in 1981, when we were negotiating the Patriation Agreement, which became the Constitution Act, it was not just a charter. I think there's a sort of amongst the general public, there's a mythology out there that all that the first ministers did in 1981 and then had it put into legislation in 1982 was the Charter of Rights and Freedoms. the Charter of Rights and Freedoms was part of a larger package. And I think it's very important when we talk about the Charter to understand it in that context, because it's one thing to negotiate elements of the Charter of Rights and Freedoms in and of itself. It's another thing to do it when it's part of a larger package where other things were at play in the negotiations. In other words, if you look at the Constitution Act today, the Charter is one of 7 items. It's one of 7 items. It takes up 34 of the 60 sections. But there are other elements in the Constitution Act and in the Patriation Agreement which were very important to the first ministers at the time. I remind your audience that the amending formula had to be agreed upon, which was really a stumbling block for everybody for the years preceding 1981 and trying to get a patriation agreement and so on, that the provinces and the federal government couldn't agree on an amending formula. So amending formula is a key part of the Constitution Act of 1982. Another part of the Constitution Act is very important that most Canadians will recognize today was the whole business of Aboriginal rights. It was the first time the First Nations of the country were recognized individually as groups, the Innu and the Inuit and the Métis, for example, and that their existing rights and treaties were to be honored. And that was a very difficult part of the whole negotiations that spanned over 17 months. So I think, and regional disparities was another one which was very important to a lot of provinces, including my province at the time. And so we were negotiating a package, and in that package was the Charter, but it wasn't the only thing. And so the Charter and what came out to be the Charter was part of a compromise between all of the parties, the provinces and the federal government at the end of the day, and it wasn't just a Charter. So in that context, one has to view it, because if you're viewing it just as the Charter being negotiated, that's one thing, but it wasn't. The Charter was negotiated in the context of other things that were on the table at the time. And so there was a compromise and ebb and flow between things in the Charter and other things like regional disparities, like Indigenous rights, like the amending formula, like minority language rights, for example. So these were all there as part of the package. And so we were negotiating. We started off with over 20 items, it came down to 12, and then we ended up with 7 in the Constitution Act. So I think one of the contributions I can make to this discussion this morning is to remind people that the Charter in and of itself wasn't being negotiated. It was the Charter in the larger context of the Constitution Act and, of course, the Patriation itself. I mean, the whole idea was to bring the Constitution home, and then the Canada Act 82, which precedes the Constitution Act 1982, there is the provisions which makes possible the patriation. In other words, the UK has no power over Canada for any new law after the Constitution Act came into force. So all of those things, both the Canada Act 82 and all of the other elements, the 6 elements in the Constitution Act, plus the Charter, make up what was agreed to in 1981. And that's extremely important for people to understand. We weren't just negotiating within the Charter and seeing what was going to be in and what was going to be out. We were negotiating the Charter and its elements in the context of negotiating 6 other things as well. And in that context, I think people will have a better appreciation for what was accomplished to that. I just, before my 5 minutes is up, I don't know if anybody's ever seen the original document, the Patriation Agreement, with the signatures on it. This is a copy of the original document on November the 5th, 1981, with the signatures. On the first page was Trudeau and Davis and Buchanan. And then on the second page, there was Hatfield and Lyon and Bennett and McLean and Blakeney and Lougheed and Peckford in the order in which they came in the Confederation. And that's the way these kinds of documents were signed. And it's the way we assemble around the table. It was in accordance with when we came into the Confederation. Of course, Quebec is not there because they didn't agree to the final proposal. So I think my contribution, especially in introducing this, is to say that the question is really not, is the Charter missing in action or has been effective? Has the Constitution Act of 1982 been effective, or is it missing in action? Thank you.
Okay, Suzanne, over to you. Success or missing in action?
Yes, thank you, John. Thanks to the audience for being here. I'm very impressed with how many people you can call out on a Thursday morning. So when I was a young prosecutor back in the day, I, as many young prosecutors did, had a steady diet of impaired driving cases. And the cases which had previously taken half an hour to establish the guy was drunk and driving the car now took a day and a half. Well, there was a lengthy argument and discussion about the infringement or not of the legal rights of the accused. And I can tell you at that time, the courts bent over backwards to recognize the legal rights of the accused under the charter. Those charter rights, of course, being fairly new when I was prosecuting in the late 80s and 90s. So the court looked after the individual. And I went out of many a courtroom grumbling because a drunk driver had got off yet again. So, but how times have changed. And I think that's really the discussion today. I then went into politics. I eventually became the Attorney General of British Columbia. The charter wasn't too much of an issue in my world, Brian. More to the issues that we dealt with were rights and title issues, First Nations discussions and partnerships and so on. I left politics in a way, although I like to still say I'm a politician. And the things that were more the issues around judge-made law, which I'm not going to talk too much about today, but medical assistance in dying, for instance, those kinds of issues. It's the last 2 years, however, during the COVID, let's call it the crisis, shocked at how much individual rights and liberties have been ignored during the time of COVID. And I'll just mention a few that really are top of mind for me. Number one, and no particular order, the religious rights. The Baudouin case in British Columbia, where there was no support really for the churches. The support lay entirely behind the government and public health office. Vaccine mandates for employees. Who owns your body anyway, your employer or you? I mean, it's not realistic for many people to say, I'm going to walk away from my job because I have to get a vaccine. So there were many, many people who felt forced to take a vaccine that they did not want to take. Mandatory vaccination for flights. Brian, I'm so pleased that you are the lead proponent in a piece of litigation over this one, because to me, it's just utterly ridiculous, unscientific, no health argument for it. It's just straight up politics that there's a vaccination policy on airlines. And then the one that was in everybody's lives every day was the vaccine passports, of course. For the first time, I think I'd like someone to argue with me on this, but I think it's the first time in human history where you've had to show papers to get into a restaurant. And not only papers, but papers which discussed your own medical status. Alternatively, of course, you couldn't get into the restaurant at all or the show. And over 10% of our population was completely excluded from the normal social and enjoyable lives that they might have had with their friends and families. So whose responsibility was this? Was it the responsibility of the politicians? Somewhat, but not entirely, because politicians go where the public wants them to go. Was it the responsibility of public health officers? Those are all the same, government and politicians. They were hand in hand, even though governments like to stand and say it was the public health officer, all her fault. It wasn't. They were working together throughout. Was it the responsibility of the attorneys general across the country? They were silent. They had nothing to say. They may have said things behind the scenes, but they certainly weren't in public, and they certainly weren't telling the politicians not to go there. Was there support from the courts? Was the court sticking up for the individuals? Nope. No, that Baudouin case in British Columbia, the churches case, is a prime example of that. And by the way, where were the churches themselves? Where were the Catholics? Where were the Sikhs? Where were the Jews? Where were the Anglicans? Why weren't they speaking up for the rights of their congregants, their rights to hold services in a COVID thinking way, but they were stopped from holding services altogether? Where were the civil liberties organizations? In BC, they were asking for more, not less. Now, I know that wasn't universally true, and in Ontario, they were quite active, and I approve of that. And the Canadian Civil Liberties Organization was quite active. And of course, we now have some individuals at the Justice Centre and the Canadian Constitution Centre, which are really standing up for people and running cases and supporting people. So that's good. How about the media? I hope we talk about the media during the course of this. The media backed the government all the way. Usually it was, why aren't you doing more, not why aren't you doing less? And then in the end, the responsibility to uphold the charter and the principles of the charter is really up to all of us. We have to all support freedom of speech. We have to all support individual liberties. We have to all support the freedoms that are in the charter. And we have to speak up to all the entities I just listed. It is up to us to hold those freedoms in our hearts. And so that would be my message today to all of you. I know everyone here who's listening is interested in this. That would be my message. The charter at 40 is missing in action. It doesn't need to stay missing in action, but at the moment it is. We can change that. I think we should, and I hope we will. Thanks, John.
Thank you very much. And Bruce, over to you.
Thanks, John. All right, so to answer the question, during COVID, yes, missing in action. But we need context here. I have somewhere in a box newspaper headlines and articles from the time when the charter was introduced. And at the time, the prevailing opinion seemed to be that, oh, well, you know what, this may be an event, but the introduction of the charter will not really affect the way our legal system works. And of course, that has not been true at all. So what you have with the introduction of the charter is, in a sense, the transformation of our legal system, at least in the constitutional sense. Our system came from, of course, the UK system, which is based upon the principle of legislative supremacy. The legislature has the democratic legitimacy to pass pretty much any laws that they want, as long as they're within their provincial or federal jurisdiction. The Constitution and the Charter comes along, and it basically changes that story. We now have a system of judicial supremacy. We have a charter that restrains the legislature, in theory, but it does not much restrain the court. And over time, over the past 40 years, we have seen courts, and especially the Supreme Court, take on with gusto, with enthusiasm, their new role, which is, in the words of Rosalie Abella in her infamous column in the Globe and Mail, the Supreme Court now sees itself as the final adjudicator of which contested values in society should triumph. That's a new thing for us in Canada over the past 40 years. Now, in addition, the introduction of the charter has to some extent transformed certain parts of our legal system into something. So that most of the Canadian legal system is a common law system, but the charter is much more like a civil law instrument than a common law phenomenon. This is an argument that Bill Gardner has made very well, that the Charter of Rights, to a certain extent, changes our legal system from a bottom-up common law system to a top-down system in which courts, and especially the Supreme Court, decide on the basis of a very vaguely worded document. So why is it that in this era, the Charter has not responded? Well, in part because the Charter does not actually mean what it appears to mean. We have this problem in Canada. We think that what we have is the best. We think this with the healthcare system. The Canadian healthcare system is the best in the world until you start to use it. And then you find out that it's not. Same kind of phenomenon is happening with the Charter. People think of the Charter as part of the Canadian identity. And it's this great thing. Except if you actually look at the way it has been used, what has happened to it over the past 40 years, the past 40 years of jurisprudence from the Supreme Court of Canada has made the Charter not what it appears to be. And so in this moment, when we are up in arms about the fact that the charter is not responding, well, we have the courts in control, and the courts have decided, for the most part, that the charter is not going to respond to this problem, that they're going to defer to the ability of the legislature and the regulators and the executive branch and the public health officials to do whatever it is that they think is appropriate. Now, one might object to that, and I have, and others have, including the people on this call. But here's the problem. We put a system into place that gave courts the ability to interpret these vague provisions in the way they thought best. And they have done that. And so, in a way, we kind of asked for it. Now, I agree that the way they've gone about it over time has not been very good. I have a lot of objections to it. But we're in a difficult spot now because we have an entrenched Charter of Rights that creates this judicial supremacy and an amending formula that Brian alluded to, which makes it very hard to change. And so, yes, I agree with what's been said in terms of people taking this on for themselves and to try and adopt a philosophy or an attitude that embraces the idea of individual rights. After all, I think it's fair to say that the charter was designed to be, it is written to be a roster of negative liberal rights in the sense that they're designed to keep the government away from you. But one of the differences that has happened over these past 40 years, to some extent, it's not black and white. There's a lot of gray, of course. But more and more, the charter has been transformed into a progressive document, a progressive blueprint to legitimize collective action. And what we have during COVID is collective action. And so the courts so far have not been inclined to say that what the executive branch and the public health officials have done should be seen to be pushing against the charter rights that we're supposed to have.
All right.
I think I'll leave it there. Yeah. Go ahead.
Thank you. I'm going to take advantage of the position as moderator to ask the first question, because I remember at the time that the charter was brought in, there was a lot of concern about the notwithstanding clause that was intended to some extent, preserve parliamentary sovereignty, but it seemed perhaps to limit individual rights. And yet it turns out that the real loophole was much less discussed, Section 1, in which the court could cheerfully find that your individual rights had been violated, but that it was in the interest of the greatest good for the greatest number. And so people talk about the government. They generally seem to mean the prime minister, the cabinet, and the caucus. But because of Section 1, it seems to me, and I'm interested in how much talk there was at the time. Brian, we'll sort of start with you. Section 1 has actually made our Constitution something that empowers the state and not the people. And if it was an accident, it was a certain very suspicious accident that Section 1 made it so easy for the judges and the people who appointed them to do whatever they like, even if it infringes your freedom of speech or some other old-fashioned right.
Well, first of all, the beginning of the charter is not Section 1, even though it's called 1, and 1 is usually the beginning. The beginning of the charter is, whereas this country is founded on the principles of the supremacy of God and the rule of law, colon. Not period, not comma. What comes after has to be used or dealt with in the context of two principles, supremacy of God and the rule of law. Now, what Bruce says is correct, what's happened in the last 40 years in that sense. And I would argue that the judges and the judiciary, so I don't know if it makes any difference in the context in which we live today, what words you had in the Constitution, that they wouldn't somehow override. Because it's clear to me that certain decisions that have been made already have totally ignored that preamble and those two principles under which the charter is supposed to be considered, number one. Number two, Section 1, the intent of Section 1 was to be used when the state was in peril, when it was an insurrection or war. It was not to be used in the circumstance that we now find ourselves in for the last 2 years. And I've gone back through a number of court cases, and I do find that the courts and the judges in this country, as in other democratic countries, do look to intent. What was the intent of that particular law or that particular provision? And that was the intent when we defined and described Section 1, okay? It was to be used in circumstances where the state was in peril. And when you have a 99% recovery rate and less than 1% fatality rate, that's hardly a state in peril. Number 3, even if one wants, for argument's sake, to consider Section 1 as applying, which I say it does not because the intent is not there, even if you did, there were 4 tests there, the most important of which are demonstrably justify. And I remember very well that we were very careful. There was a lot of argument about the word justify, and several of the first ministers, including yours truly, Premier Bennett of British Columbia, Lougheed of Alberta, and Blakeney of Saskatchewan, I remember well, and Manitoba as well, were very insistent that we strengthen that provision. And that's why demonstrably got in there. Now, in any normal, reasonable person, sane person, when you say demonstrably justify, in all of the work that I did in the 17 years I was in politics, and the 10 years that I was premier, demonstrably justify means that you have to somehow find, before you implement your new measure, that the benefit outweighs the cost and what you're going to do. Otherwise, why would you do it? No real effort has been made by any of the 14 governments in the mandates to satisfy demonstrably justify, nor have they done anything to satisfy free and democratic society. A free and democratic society, again, under any reasonable circumstances, would have to be defined in Canadian terms as parliamentary democracy, free and democratic society. And the parliaments have not been, they've been only open long enough to give the bureaucrats more power and then close again. There should have been select committees in all 14 of the parliaments of this country where that select committee of the House or of the legislature oversaw what was happening and examining what the government was trying to do. And you could do it on an expeditious basis too. There's a lot of science out there that 90 days after the virus was so-called declared a pandemic, that there was data available which showed that it was highly likely, more likely than not, that the cure was worse than the disease. So my argument is, and I've been making this strongly, number 1, is what happened to supremacy of God and the rule of law. Now, Bruce talks about the charter being vague. There's nothing too vague about that for me. Supremacy of God is easily defined from what we know over the years, nor the rule of law, nor is freedom of speech, freedom of conscience, freedom of religion, freedom of the press. These are pretty clearly articulated. These words mean something, and I don't know that any first minister sitting down would be able to define them any more specific than they're defined there. Freedom of association, freedom of assembly. They're, to me, easily to define beyond that. So
let me bring in the other panelists at this point. Bruce or Suzanne?
Sure, yeah, so I mean, I wish things were the way that Brian is describing, but that's not what has happened to the charter over the past 40 years. Now, here's an irony we should acknowledge. Over these past 40 years, the pattern has been this. People on the right have been critical of the court's approach, the court's expansive approach, imagined approach, creative approach, the living tree approach,
right,
to interpretation of the Constitution. They have objected to those moments where the courts have said, well, we're going to read this broadly so as to extend rights in a way that might not actually be written down. And the progressive left has championed the living tree and the expansion of rights and the creative interpretation and so on. Here's the irony. During COVID, these positions have flipped. The progressive left says, oh, no, 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 no. Only the rights that are written in the charter. We read those textually and narrowly, and these restrictions during COVID do not infringe those charters as they are described. And the right has said, what the hell is going on? you're not allowing me to fly. That surely must be contrary to the spirit of the rights in the charter, and I agree with that. But they're contrary to the spirit, the values, the charter values that before COVID came along, we were all very critical of. So this is not straightforward. We are now championing an approach to the charter that for a long time we criticized and the left insisted upon. And the left now denies that that's legitimate. And now we're complaining that expansive approach does not also apply to us.
John, let me just go back to that Baudouin case, British Columbia. As the BC Supreme Court Chief Justice of the British Columbia, the Chief Justice of the court, took all the teeth out of Section 1, that demonstrably justified. Everything vanished in Section 1. The government lawyers in the case agreed that there had been a breach of this right, that right, and the other right. They agreed all the way through, yes, all these rights were infringed. However, Section 1 saves us. And with very little analysis, certainly, Brian, none of the analysis that you talked about just now about war or insurrection, nothing. It was just a weak, tepid analysis. Sorry to the Chief Justice, who I like very much, but I disagree with him respectfully on this one. It was just, it really just said, there, Chief Public Health Officer, you're doing a fine job. Therefore, your order is reasonable, which is part of the discussion. Is the order reasonable? Yes, the order is reasonable. And that pretty much ended the discussion. So as far as the law in British Columbia is at the moment, Section 1 has no teeth whatsoever. As long as what the public health officer is doing is reasonable, there was no consideration that the churches had offered to, have spacing, have masking, have only so many people. They had lengthy arguments about what they would do that was COVID compliant, but those were not accepted. So that section has completely lost its teeth. And I think that that's the peril that we face as this country. Now, it's under appeal and there may be other litigation that comes along. I think courts, like everyone, are influenced by the public opinion around them. And I think as the fear of COVID recedes, I'm hopeful that the courts will turn more to the rights of the individual. And Brian, your case on the vaccines, which I do think on the airlines, which I think is particularly egregious because there is zero health argument for it. Nobody has ever got COVID on an airplane, believe it or not. Or maybe one or two, but Air Canada will say nobody gets COVID on a flight. So there's no health argument for that. It's simply a political decision that was made. And I hope, I'm an optimist, that over time the courts will start to rule more in favor of individual rights.
Okay, I'm going to combine two questions here. We should let our audience ask a few questions to add to the discussion. So one question is, which specific charter rights is it that people claim are being violated by the various mandates? And to what extent, if those rights are being violated, does the charter provide protection against provincial acts as well as federal ones?
Well, first of all, I respect you as the moderator and posing questions, but I have to respond to what has been said so far. I'm sorry, but it seems to me we are where we are. And to respond to Bruce, whether it's right or left, or whether it's ironic or not, we are where we are, and I'm not interested in engaging in whether it's from the right or the left or anywhere else. I'm just interested in that we have a document that I helped create, and that, in my view, it's been abused by the governments of this nation right now in the last 2 years. That's what I'm really interested in, and that's why I'm fighting so hard. Now, and I also say, and I agree with the last speaker on this, that we're in the latter part of the second period. The game is not over yet, even though, as has been mentioned, the British Columbia Court and the Manitoba Court at the lower levels of their Supreme Court, not the courts of appeal, but at the lower levels of their court, have ruled in favor of the government and completely ignored demonstrably justified or free and democratic society, supremacy of God, rule of law, and all of that, which are pretty clear in my view in the Constitution and are not unlike other kinds of bills of rights in other jurisdictions. So yeah, we're in the latter part of the second period, and we've got the third period to go. That's the courts of appeal and the Supreme Court of Canada. And I come down on the side, and even though I know what has happened and how it's been abused so far, And I am also very aware, and I read them every day, every case that's gone since the Constitution Act has been passed in 1982. I read most of them again last night, and I'm aware what has happened as it relates to the living tree. But we're still in control if we want to be. We're still in control if we want to be. And I think like debates like this and people speaking up will influence the court. And I am still hopeful that the courts of appeal, wherever that is heard in the provinces, quite likely 3 provinces, I don't think all the courts of appeal will hear it, and then it will go to the Supreme Court of Canada, that by that time, the judges will have had a little change of heart and see that they have not really been interpreting the Charter of Rights as written and as is most people in Canada understand it to be when you say freedom of speech, freedom of association, freedom to travel, and all of that. These are pretty clear in my view. And so I would very much say to people that, and if at the end of the day, the courts continue to rule as they've ruled, then I think we're in a position where the country has to decide whether you have a new constitutional conference and amend the Constitution Act or the Charter to be more specific in those areas which obviously the courts have misinterpreted, if you can do that. I doubt whether you can. Because very often when you open a constitution, like we did in 81, it's just not the Charter that will get on the table. There'll be other items that other provinces want to put on the table. So beware what you're going to ask for if you're asking for reopening the Constitution, because that's going to be very difficult. And once again, it will be, like I said at the beginning, a combination of things, including the Charter and not just the Charter. So I'm still hopeful, and that's why I've taken out my own lawsuit, is because I believe that at the end of the day, the courts are going to have to reverse some of the decisions that have been made by some of the lower court judges, which I think in a frenzy like a lot of the world was, and a psychosis like all the world was, got the emotion overruled the rational side of things. And they thought that the millions were going to die in the street, like the Imperial College of London said and the University of Washington said, all of which were completely wrong. And so I'm still hopeful that these provisions that are in the Charter as written will be defined in a reasonable way. And if they are, then the people win and the individuals win at the end of the day. If not, then we have to look at a new way of governing our country.
Okay, so Suzanne, which rights are people claiming are being infringed, and to what extent would that apply if it's provincial action rather than federal?
Yeah, so the Charter applies to government. So the actions of the province of the government of British Columbia are definitely subject to the Charter. In fact, in court-made law that's been expanded beyond the government, but we don't have to go there right now. It's what government does, which includes the public health office, the chief public health office. And so the funny thing is, I think about the restaurants rule, and Brian, I'm sorry, you didn't include in here that you had the right of a business to serve people and the right of people to patronize businesses. Nobody, I think, would have ever dreamed that you had to include those kinds of minutiae. But that's the trouble, as Bruce said, with the civil code rather than our general freedoms. John, I've been watching some of your work on the Magna Carta, and I would like to give you a plug here and have people go back to our historic antecedents of freedom. And it has never, ever in our whole lives been thought that you had to be specifically given the freedom to serve people who you want to serve and a restaurant and who can go in and out of a restaurant. The unvaccinated, if you say the restaurant can't serve a certain group of people, you can put any word in there and it is offensive. And at the moment it happens, but fortunately in British Columbia, they've finally taken the rule off, and I think the other provinces were a little quicker. But you can certainly include those freedoms of the fundamental freedoms of conscience, religion, thought, belief, opinion, expression, assembly, association. Certainly all of those different things can be found within section 2, which is a pretty broadly worded section and can be interpreted broadly.
Yeah.
Remember, this is a constitution, not a federal act. Go ahead, Bruce.
Sure. Yeah, but part of the problem here is that the Charter is not, as you both alluded to, the Charter is not well designed to hold back an expansive administrative state. And when courts embrace the existence and the needs of that kind of bureaucracy, and what they've done over the past 40 years, the pattern has been that whenever there's a question about the ability of this nanny state to do what it needs to do in the public interest, the court has gone out of its way to make sure that it has those abilities. And so we have now a state that is encroaching in all kinds of ways that were probably would have been a complete surprise at an earlier time. But the charter is drafted so as to protect negative rights. That is the right not to have the government interfere with you. And if they don't interfere, then the right's not breached. But our administrative state now exists in a situation where it controls pretty much everything. When it says, well, you can move across the country, but you can't fly, their interpretation of that is, well, we're not limiting your mobility, we're not limiting your liberty, we're just saying you can't get on a plane. And the insistence that you can get on a plane is a positive right. And our problem is that if the charter is what we have always said it was, which is a roster of negative liberal rights, then some of the things that the state has done in this era won't fall into that bucket. What has really happened here is that the virtues, the values of liberty have fallen off a cliff. And we have all kinds of institutions approving, and the public as well, approving of the idea that it is the job of the state, the job of the experts and the bureaucrats to keep us all safe. And if they need to do things that limit our abilities to keep our job without taking a vaccine, then everybody's fine with the idea that the charter doesn't capture that. And according to a strict reading, they've got a point. The problem is the charter is not designed for the world that we live in now.
I disagree with that. I disagree with that. And I disagree with your terminology of negative. Freedom of speech is not negative.
Yes, it is. Yes, it is. It's entirely negative.
It's not negative.
If it's
positive.
a
It's very
positive, a positive right to freedom of speech would mean that you have the right to be published.
So
And a negative freedom of speech means that the court can't, the government can't censor you. It's quite different things.
I think where we're getting into trouble here also is that a democracy and any kind of constitution or charter that's ever written is only as good as the civic engagement of the individuals. So that's one of the things that's happened in our country in the last 40 years, is that we've laid back because we've been materially fairly comfortable and allowed the so-called experts to run the show. And then all of a sudden, when they were personally impacted and saw what was happening, oh my God, well, they can't do this, can they? And so I think in order for any charter or Bill of Rights to work in the way it was written, it will take a massive civic engagement of the people to say, we don't agree with the way, courts, you are interpreting this. Here's how we think this was meant to be. And being one of those who was there and helped write it, I can tell you how it was meant to be. And I've got it written down here in files on top of files to back up my case, as well as the intention of section 1. So it seems to me that where we've really fallen down is that we have allowed the administrative state to interpret erroneously a lot of the laws, including the charter, that are supposed to apply to the individuals of this nation.
I agree.
I think that's very sad.
I totally agree.
And it's up to you and me. It's up to you and me and everybody else to
I agree.
on the horse.
Totally agree with you, Brian. I totally agree with you. But so let's just underline this point though. We are really late to this.
Yes.
Really late.
Yes.
This has been happening for 40 years.
Couldn't agree
And
more.
it's taken COVID for us to wake up and see what's happening.
I
So
agree.
we got to get on the bus.
Yeah, but better late than never. I mean,
Fair enough.
we're totally wrong. And I have in every speech I've given said that we're very late in the day of doing this. For example, I didn't even know myself until 1990 that people were writing books and describing what happened during the Patriation Constitution, which was complete mythology. The Light of the Long Knives never happened. And there's books written on it. And the Encyclopedia of Canada still has it in there. A completely erroneous way in which this all came together, for example. So I'm part of the problem in that sense, that you go about and do your work and all of a sudden you realize what's happening here and what happened. So yes, we're very late in the day. I couldn't agree more. And that's
Okay,
why,
and-
you know, every morning now I get up and until I go to bed at night, all I'm doing all day long is giving speeches, answering emails, trying to get people engaged, to say that if you don't get engaged, and if you believe with me that some of these provisions in the charter are worth defending, you better get out and start defending them. Otherwise, they're going to be gone for good, because the courts will go with the opinion of the governments if they see that still as being the dominant popular opinion. So we're only as good as, look, any democracy in the world since Socrates, we all know, if civic engagement is high, democracy is high. If civic engagement is low, democracy is low. And right now, democracy is low in Canada.
And this is a perfect segue to, I'm going to combine several questions because people have been asking, how did we let this happen to ourselves? What happened to the people? And also, what can we do? And so we see clearly, yes, this need for much more civic engagement, but what specific practical, people are saying, how can we push back against the courts, or how could we engage the politicians? And so I want to ask the panelists in practical terms. It's marvelous that people have turned out. I'm amazed over the last couple of years to discover there are more people working on this than I knew about. I just recently connected with someone I hadn't seen since high school who's fighting the University of Toronto's vaccine mandate. So there are people out there, but what, panelists, for the rest of the session, I want you to tell us, what do we specifically try to do to change the situation and get things back to where they ought to be?
So let me start on that one, John. The most important of all the rights, I think, is the freedom of expression, the one Bruce just alluded to, and Brian, the right to be published, the right to speak, the freedom to speak up. This is the one that actually worries me the most, because we have not had free debate in this country.
No.
We have not had debate about vaccine safety, which concerns many people. There's been very little argument in the mainstream media about the issues over the last 2 years. There's certainly censorship. I'm sure a lot of people on this session are watching with fascination the Elon Musk / Twitter issue. Twitter, of course, having kicked off many people. All the most interesting people have been kicked off Twitter in the last couple of years. And in a Canadian context, we need proper debate in this country. We need the mainstream political shows on the evening TV to be talking about this. And I guess that is up to all of us to just keep speaking up and speaking up. Because without that debate, without that conversation, we are putty in government's hands. And of course, administrators love to administrate. I've been in government. You're elected. You figure you know things pretty well, and you like to make rules for other people to follow. People should have the opportunity to object to those rules. They should have the opportunity and the ability to speak up. That would be the most fundamental of all. And that's something that we can all talk about all the time.
So part of the dilemma here is that all of the things we've been talking about, the charter, legislative supremacy versus judicial supremacy, asks the question, you know, where do you want the power to lie? Do you want it in the courts? Do you want it in the elected representatives? Do you want it in the executive? And the problem right now is those three branches, there are all those exceptions, of course, but those three branches are largely on the same page. They sometimes fight, but they often cooperate. And so that's not really the question. The question is it the states altogether, those three branches, or is it the individual? And as long as you have the idea that you can balance powers with checks and balances, you know, in the charter or in the Constitution or legislative powers and so on, is, you know, if the legislator does this and the court can do that, that's not the point. The point is the state should be out of it for the most part, and people should own their own lives. Until you get that idea back into a country, we're going to be caught in an indefinite conversation about, you know, where the checks and balances should lie and who gets the last word.
Nothing is perfect, as we know from the time, I guess, we were 5 million years ago when as a Homo sapien, we started to crawl around the prairies of Africa or whatever. Nothing is perfect. We're a very flawed species, if you will, but we have created various instruments for us to associate and assemble and govern ourselves. And so we are today as it relates to that. I do think, though, that so there will never be clear lines. There's always going to be a dynamic tension between, if you're into a democratic kind of framework, between the legislative and the executive and the judiciary. There's always going to be a sort of dynamic tension, and therefore civic society therefore comes into play to ensure that that dynamic tension between the three is always fairly well balanced. So the rights of people are respected. What the parliament has to do, it does. What the executive has to do, it does. So it's within that framework I sort of operate. Now, you ask, well, what can people do today besides these kinds of debates? I'm chairman of Taking Back Our Freedoms, which is a national organization, which is about trying to restore the Charter's real meaning. And I'm honorary colonel of a new organization called Veterans for Freedom. And I'm involved with the Citizens for the Charter of Rights and Freedoms as well as a patron. So besides taking a court action, so a lot of people can join various organizations which are out there to try to, and I say this in all my speeches, say to the academics, to the judges, get out there so that, because judges are also people and they read the newspapers and so on. And so the more people join organizations like We Unify, Vaccine Choice Canada, Take Action for Canada, and there's 80 of them out there right now across the country. Join an organization and write your MP and get out to all these rallies. We had 13,000 down on the steps of the legislature building in Victoria several weeks ago. Quite likely this May, when we have another one, we're going to have in the tens of thousands. And so I think this will have an impact. So that's what we got to do. We've got to join, and civilly disobey. In other words, peaceful protests, so that the authorities and those in power, especially in the judiciary, realize that the people are not on side with a lot of the things that they are adjudicating today, and they're taking a lot of the stuff out of context, not using good data, and so on. And so I think that's where we have to put our emphasis right now. As a people in this country, we have to civically get involved, and I think we can make a difference before the final adjudications come on most of the court actions that are underway right now.
Agreed. I think the weight of public opinion has much more of an effect than we give it credit for, even in the courts.
Exactly.
There's this theory that the courts are immune from public opinion.
Yeah, they're not.
I think the evidence shows that that's not true.
Exactly.
And I agree with that, which is why I'm hopeful on some of these appeals. In a way, I think it's a good thing that they have gone on beyond the period of people's fear. I mean, most people are just getting on with things now. I know I follow a number of people on Twitter who are still worried. But when you look around your daily lives, I certainly don't associate or live with many people or have family that are terribly worried anymore. People have learned to live with it. And I think you're right that the courts will feel that and see that. And I hope that they will back up and take, since we're now in the hands of the courts, take the individual rights and freedoms, personal freedoms that are in the Charter, and stop brushing them aside. It is an important document. We were bound to have it, Brian, one way or another, and I'm really fascinated by hearing you talk, having been there and having been in the negotiating room. So we've got it. It's what we've got. I think it can be read broadly and expansively for individual freedoms. That it hasn't been recently is a problem, but as I said before, I'm an optimist. I hope that it will start to be read that way again.
We should also acknowledge, though, that this is a much broader problem than just the Charter. The Charter is a symptom, if you like. We have,
I agree.
Most of our public institutions today are operating on a different ethos than the one we're talking about right now. And so in order to push back on all of that, including the way the Charter is being used and abused, but also to change the channel on the way public institutions are behaving, we really need to have this sort of a massive change of public opinion, of public sentiment about how they are being managed. I think it's time for the Canadian population to say, we do not want to be managed anymore. Back off.
Right.
And give us our lives.
I couldn't agree more.
I couldn't agree more.
But by the way, to come back to what we never got to talk about very much is I have not been able to get a letter published anywhere in Canada in the mainstream media. Before the pandemic occurred, they would carry my letters. Nobody will carry my letters now, nor interview me about what's going on in this country. So there is censorship underway in this country, which has to be changed too. So not only the public institutions as it relates to government, but the media who've taken their $600 million and run with it, right? There's a trusted news initiative that all of the main parties in the world, in the Western world, have signed, saying we will not carry anything in our platforms unless it's something that we agree with. I mean, this is absolutely atrocious and egregious, and it's completely against any kind of democratic principles. The media has to be changed too and become independent. The educational system has to be changed. There's got to be civics in the schools, starting in grade 8, so people will know what their country is all about when they graduate from high school. Right now, they don't have a clue.
Okay,
Yes.
time is running
I
out.
agree with that. And
Suzanne,
sorry,
you
I think
get
we're gonna
the
go.
penultimate word. And then it's me and Troy. Suzanne, last word to you from the panel.
Yeah, sorry. Let's do a forward-looking panel, Troy, and not today, obviously, but where is this going to go in other areas? So the digital ID that's been proposed,
Yes.
Canada has signed on with the prospect of an international digital ID. Where does that leave us as citizens? The climate debate and all the various proposed things that lie there. I'm not going to go into any of that at the moment because but there will be charter issues engaged in all of these things. And anybody who wants individual liberties, certainly the liberties of ourselves as a sovereign nation, we do need to be paying attention. And I compliment again everyone who's watching here today because you are all engaged. Thank you for that.
Okay, on that note, so I'm going to very much thank the audience for coming and listening to our outstanding panel. Also very much thank the panelists. And I'm going to put in one more pitch for something to do. And I have a dog in this fight, but it's okay because it's a nice dog. And that is that everybody who is concerned about these issues needs to find a way to make some support to the sort of infrastructure of freedom. In this country, every year, people give millions of dollars to political parties, most of whom then disappoint you bitterly, especially if you are devoted to classical liberty. But the organizations, and this includes, the JCCF, the CCF, the Fraser Institute, Macdonald Laurier, the Frontier Center, the Montreal Economic Institute, obviously True, Strong, and Free, and our own Climate Discussion Nexus. And I'm going to invite you all to also to come to this conference we're holding in Alberta on a shoestring with the Economic Education Association of Alberta. But if everybody can find a couple of dollars a month for 8 or 10 organizations, one restaurant meal, divvy it up, because we need to keep pressure, giving people a place to go for resources, outlet for their views. And of course, one of the principal organizations you should support is True, Strong, and Free. So Troy, over to you for the last word.
Okay. Thank you, John, and to our panelists. That was a great discussion. And again, so many people asked again in the comments, but this will in fact be posted to our website, into our YouTube page. We'll have it up in the next couple of hours, and we encourage you to spread it far and wide. Send the link around to let other people take in this great information. A reminder again to register for our conference May 5 through 7 in Ottawa. A special thank you for our sponsor today, again, the Modern Miracle Network. We are the Canada Strong and Free Network. And if you appreciate and value the work we are doing, please consider a donation. Thank you, everyone, for joining. We won't be here next month on here, but we will be back in June. Thank you. Enjoy the rest of your day.